I visited the Capitol yesterday, and so that I could gently remind my former colleagues that how much I enjoy being able to leave at 5 p.m., not 5 in the morning. They didn't think it was so funny. It's great to be here, and I'm thrilled to have the opportunity to come speak to you on this important issue. What I'd like to do sometimes is kind of give an overarching framework and then bring it down to the specific issue at hand. Everybody knows that the Office of Attorney General exists. What I find, even when I speak to groups of lawyers, most people don't really understand exactly what it does and the scope and breadth of its responsibilities. The short version is that we reach into every nook and cranny of public life in Connecticut. I've got 210 lawyers, which would make us the largest law firm in the state, if you want to view it that way. We handle more than 54,000 individual cases per year. The main thing we do is we're the state's lawyer. We represent the executive branch of office and other branches of government in enforcing Connecticut laws. We also represent the state when the state gets sued, which is not infrequent at all. But a third aspect of the job that's not fully appreciated is that, and this goes back to the King's England hundreds of years ago, where the representative of the sovereign didn't simply enforce the king's law, the sovereign's law, but was entitled to go out and act in the broader public interest. And this is a responsibility of the office that is well established in common law dating back to that time. And so this is where the job really can be very interesting, because it allows individual state attorneys general from around the country to kind of put their imprint on the job and forward their own priorities. And so when I first came into office 4.5 years ago, one of the big things we were working on was cleaning up the mess left by the '08 financial crisis. And so immediately I got involved with the national mortgage foreclosure negotiations, where state attorneys general eventually took a year, reached a deal with the 5 largest mortgage servicers in the country who had systematically rode roughshod over the legal rights of their clients. And we reached a $25 billion, that's billion with a B, mortgage settlement. Most of that billion was in the form of credit relief to distressed homeowners. And in Connecticut, concretely, that meant we brought in more than $450 million in credit relief to distressed homeowners, helping more than 6,000 Connecticut families stay in their homes. To help assist that process, and again, this is in the category of, this is not legal advocacy, this is acting in the broad public interest. I worked with the Malloy administration to host, I think it was 8 what we call mortgage servicing events around the country, where we would get representatives from the banks into like the Harbor Yard in Bridgeport and the Convention Center in Hartford. We brought in legal aid attorneys, housing specialists, counselors, and we averaged more than 1,000 people per event to meet with their mortgage servicers and hopefully bring relief. Other areas of public interest, I'm very active in environmental issues, especially open space and habitat preservation. But one of the biggest areas that I've been involved with, and when I was campaigning for office 5 years ago, if you had asked, where does personal data privacy fit on your agenda, I would have said, well, it's an issue, but, and I'm sure it'll grow as an issue, but I would not have expected the primacy that emerged very early in my administration. When I came into office, I found that it seemed like not a week would go by without some data breach being reported to me. Another flip side of the privacy issue is how products are being launched by large corporations, the Facebooks and the Microsofts and the Apples and the Googles of the world, where that had implications for the use of data that these businesses had legally acquired because people gave it to them, in effect. But there are significant policy considerations as to what's the proper scope of that use. And so very early on, both faces of the data privacy issue were front and center in my office. Those two issues obviously being data breaches, but then completely separate, but also in the realm of data privacy, how these large corporations are using this legally acquired data. And what bothered me the most was that my office was exclusively reactive. We weren't being proactive in terms of coming up with policies that for prevention. And this is an area where an ounce of prevention really is a pound of cure, because if a product is launched, the cat is out of the bag, tough to get back in. If a company has been hacked into, those records are lost. Early on in my administration, in June, it's only 5 months into my administration, I also noticed, I should observe that with respect to the data breaches, it cut across the different silos that exist in my office. We have separate departments. There's the data breach issue affected financial services. It affected healthcare. It affected consumer protection. And so I thought we needed to kind of broaden the reach of anything that we're going to do. And so when I created a task force on data privacy to examine both of these aspects of it, I brought in attorneys from the different departments that were most affected. And their charge was to look for ways to be proactive. One of those was to meet with industries and not-for-profits, develop a set of best practices, which we've been reaching out to the business community and to the not-for-profit world to encourage them to adopt. And this is anecdotal, but I think that, and there is some data to back it up, but I think that a lot of businesses have moved from data security being something that they kind of want to do, and we'll get to it when we get to it, to being a very, very high priority. Mostly this is driven by the breaches that have occurred and the price that's paid for that, but I would like to think in part it's because of the publicity that we've tried to bring to that issue. One of the things, so we've reached out to the business community, to the not-for-profit world, to encourage moving this issue to the front burner. We also very early on realized that while we had a strong data breach law in place that empowered my office to enforce, to investigate data breaches and where appropriate seek fines or changes in behavior, there was no notification requirement. It took a year, but legislation that we sponsored became law in 2012 that required, when a data breach occurs, that my office be notified. This law went into effect on October 1st of 2012, and overnight, the number of reported data breaches quadrupled. And we're averaging, since that time, and the first 3 months of this year, as consistent with the pattern, about 400 data breaches being reported every year. Now, most of these are small and inconsequential, no harm, no foul. A laptop is lost. There's no it's encrypted. There's no evidence that it's being used for nefarious purposes. But we investigate every one, and most of them are, again, inconsequential, but there are a lot that are not. And so what do we do when we investigate? We send out a letter that has a detailed set of questions as to how the breach occurred, what caused it to occur, what data specifically was lost, and what is being done to ameliorate it, and what steps are being taken to ensure that this does not happen again. When we investigate, we understand that businesses that have been hacked into are victims. They are victims as well. And we try to be proportional, we try to be fair, we try to work with the business community and not-for-profits on this. And we encourage people to work with us. It's critically, what we don't like is when people are resistant in providing us with information. They delay in providing information, and they are resistant to efforts to correct the situation. And so we really bend over backwards to work with the victim and correct the situation. That's the goal going in. Now, one instance of a well-known not-for-profit, they lost a computer was taken home, unencrypted information, it was lost. We worked with them to develop new policies that would hopefully prevent that kind of thing in the future. We did not seek a fine. even though a lot of information was clearly compromised. A year and a half later, the same thing happened. We weren't as nice to them the second time as we were the first time. So this is a growing field. It's a growing area. The scammers and the hackers are one step ahead of us. It's going to continue to be a priority for my office, and that's where we'll go from there. I'm going to stop talking in just a moment and take questions, but I just want to say I love going to work every morning. There's people and honest businesses need more than just a voice. They need a true legal advocate who's out there to protect their legal interests in situations where they cannot do it themselves, and I'm the lucky guy who gets to do it. Thanks. Questions for anybody? Yeah.
Congress is looking at trying to preempt breach notification laws. Look at how what they're doing with impact today.
Yes, I have, and I'm not against Congress getting involved and establishing a single standard around the country, as long as that standard does not dilute what we have in place, because I understand the perspective of businesses, particularly national businesses, that don't want to have to deal with 50 different individual state laws. But with the following caveats. The one I've just given, which is it better be a good law, a strong law that protects consumers. The second thing is I am completely against preemption that would prevent state attorneys general from having enforcement powers, and for several reasons. The first is that we're good at enforcement. We are far more nimble than the feds. If the enforcement's left exclusively to the feds, you're going to see a hell of a lot of data breaches that are essentially unmonitored and not investigated. And so that would be really, really bad news. Businesses would not feel the need to improve their game. The second reason is that, in addition to the, being more nimble, we know the terrain. We know the businesses on the ground. I think we do a better job. The third reason is that this is not unprecedented. State attorneys general have HIPAA enforcement powers. It's worked well. State attorneys general act on the ground on behalf of the CFSB and for consumer protection issues. We can do a good job. We do a good job, and I would be totally against the state attorneys general being taken out of the equation. Understanding again that it's not a bad thing to have a single national federal standard as long as it's a good one. Yeah. Can you speak more loudly, please? I don't think people can hear you.
Can you talk a little bit about what's some of the processes and what's some of the capability you can do for providing greater communication paths, particularly for the hospitals and the healthcare providers? So when we see something or when we suspect something, we can get more lateral communication as to attacks, vectors, threat awareness, anything of that source without the conflict of the PHI getting in the way?
Well, Michelle Lucan, who's sitting back there and who's going to be one of the panelists, is part of my newly created. I should have mentioned also, after creating the Privacy Task Force earlier this year, I turned it into a full-fledged department within my office, and I'm the first Attorney General in the country to have created a department exclusively devoted to cybersecurity. It's just like consumer protection or environmental protection, employment rights, and all the 14 other departments that I have. I would say open a line of communication with someone like Michelle from my office, so that you have a person you can go to who's a resource. We're, as we like to say, I'm from the government. We're here to help, and having a relationship with someone in my office who's on the ground on it, I think, is the best single way to do that. One more question. Yeah.
So when you speak in terms of hacks, there's generally, from my knowledge of the sector, there's generally two things that are leaving a facility or a database. So one of them, of course, is intellectual property trade secrets, and the other one, of course, is PHI and also PII, identity theft. My question for you is what sort of focus, if any, is the state putting on the growing problem of identity theft of minors? And the concern, of course, is that if the identity of a child, of a 12-year-old, for instance, is stolen, they don't find out about that until they're ready to go to college some 6 years later, and repairing their credit and getting their identity back, of course, 6 years after the fact is obviously a nightmare come true.
Yeah, you raise a very good point, which is the hackers don't give a darn about George Jepsen, age 60's Social Security number. They want the young ones. And unfortunately, there's very little that we can do except to encourage, shine a spotlight on this issue and encourage parents to be aggressive in identification and prevention. That's really...
Is your office also working with, for instance, the schools and public service agencies and that sort of thing to help educate them?
Not very much at this point. That's something, we're very resource challenged in my office. It's something we should be looking at, though. You raise a good point.
Thank you very much.
Bruce.